It's just summarise for us what we've been hearing.
Well, we just heard from Lord Hodge, who was presiding over this case. There were 5 judges who were making this incredibly difficult decision, but he said that it was an unanimous decision between the 5 judges, that in the case of the Equality Act, the 2010 Equality Act, when it refers to woman or sex, it is referring to biological sex and not somebody who has a gender recognition certificate. That was what this case rested on. It was effectively the judges here were being asked to make a decision on the correct interpretation of the Equality Act. Was it limited to biological sex, or could it also include someone with a gender recognition certificate? But today, the judges have decided and ruled in favour of For Women Scotland. They were the ones who appealed against the Scottish Government. They wanted to have clarity on the law in regarding this, and they have indeed had that clarity. I mean, you can hear some of the people behind me clearly delighted by the news today from the Supreme Court that when it comes to the Equality Act, it is referring women and sex is referring to biological sex. Now, this will be welcomed by For Women Scotland, but of course there will be transgender campaigners and those in the transgender community who will be very disappointed by the decision today at the Supreme Court.
Alice Porter outside the Supreme Court for us. Thank you so much. Let's bring in the legal commentator, Joshua Rosenberg. Joshua, just distill for us what we've been hearing. That was quite a long and complicated readout by Lord Hodge there, and he acknowledged that actually the full ruling goes far, far more extensively. What were the key points for you?
It was a very clear ruling, and Lord Hodge made it very clear at the outset that he was allowing this appeal by the Campaign Group for Women Scotland. The unanimous decision of the court is that the terms women and sex in the Equality Act 2010 refer to a biological woman and biological sex, and he excluded what's been described as certificated sex, meaning somebody who has a gender recognition certificate. So this is a way of bringing clarity to a very confused area of the law. I think it's a very practical decision. It's a very common sense decision. It's a decision that gets round the practical problems that he outlined, which is how would you know whether somebody was born a woman or has a gender recognition certificate making them a woman, because you can't even ask them if they have a gender recognition certificate. That's private. How would you deal with all the problems of single-sex spaces? How do you deal with the problems of lesbian groups, of other groups who rely on what's sometimes described as natal sex? But as you heard, Lord Hodge went to considerable lengths to say that although this was a victory for the campaign group, it wasn't a defeat for the trans community. He was making it very clear that their rights are protected. It doesn't mean that they can be discriminated against. They have rights under the Equality Act. It is a defeat for the Scottish Government, which issued this guidance. It's overturning the Scottish courts, which upheld the guidance. Worth bearing in mind that Lord Hodge and the President of the Supreme Court are both from Scotland. They're both former Scottish judges, and the other judges, the other members of the court included the female members of the court. So it's a very clear and decisive decision, which is something that people who feared there might have been some sort of fudge, some sort of grey area, will be pleased with, even though it's a defeat for one side, to the extent that Lord Hodge says that, well, they still have their rights, and a victory for the campaigners who wanted women to be defined as people born as women.
You said that it was clear and unanimous. The hard work, in many respects, now starts again for the Scottish Government, doesn't it, and the UK Government, because they now need to react to this and consider how this now impacts the laws that exist and possible new laws that come into effect, surely.
Yes, that's right. But all this was about was whether you could increase the proportion of women on the boards of public institutions in Scotland, something the Scottish Government very properly wanted to do. And if you were going to include women on these boards, do you mean people born women, or do you mean people with a gender recognition certificate? The Scottish Government said it ought to be people who had a gender recognition certificate. Well, that was fair enough. That now won't work. But nevertheless, the original legislation, which says that there should be more women on these public boards, that's perfectly okay. It's just a question of how you define the women. So I'm not sure that it requires major changes, but certainly those who argue that for these purposes, people with gender recognition certificates recognizing them as women should be included, they've been defeated on this. But of course, they can still join these public boards. They can still do everything else they wish to do. And above all, as Lord Hodge stressed many times, they cannot be discriminated against on the grounds that they have changed their genders.
What impact will this decision have on other elements of daily life? I think, for example, women's sport, bathrooms that have much been talked about prisons. That's been a hot topic of debate in Scotland in particular, about women-only services and the provisions of those. What does this mean for instances and elements such as that?
I think it strengthens what many people would regard as a common sense approach. There's great concern, isn't there, about people who were born male who turn up at women's changing rooms, who wish to take part in athletics events reserved for women, who wish to go to prisons reserved for women, and so on, simply by saying, well, I identify as a woman and therefore I should be allowed in, or even if they've gone to the trouble of getting a gender recognition certificate, as I don't think very many of them do. And what this means is that those people will not be able to do so, because what the court has said is that for the purposes of the Equality Act, we're talking about biological women. Now, that doesn't directly affect sports and changing rooms and so on, but nevertheless, it does, I think, damage the case of those who say, well, I identify as female and therefore you should let me into a sport, a safe space or something like that, which has hitherto been reserved for biological females.